The next step of the analysis is social harm. That's element number 2. We don't punish people for their voluntary acts as such. We don't punish people even for their omissions when there's a duty to act. We punish people when those voluntary acts or omissions result in social harm. So what do I mean by social harm? Well, first notice that I put the word social in that description, which is to remind us that we're dealing again with the criminal law, not tort law. We're dealing with harm to the whole community, to society, and not just to the immediate victim. Because remember what I said before, a criminal conviction is a statement by the whole community condemning and denouncing the individual. It's the people of the state of New Jersey or Texas versus Smith. It's the harm to the whole community that's being condemned. Now, of course, the primary victim of harm in most criminal cases is an individual or a small number of individuals. But the whole society is harmed when a person commits a crime. I mean, after all, when you learn about a crime occurring in your community, doesn't it affect you and how you live your life? Perhaps you don't go out at night or don't go to certain parts of town because of your fear of crime. To the extent that that fear is reasonable, we can say that your liberty has been impaired by that criminal. You have been harmed too. And furthermore, hasn't a person, by committing a crime, torn the fabric of society, at least to some small extent? So there is harm to the whole society in criminal law, and so we call it social harm. Now, in trying to determine what the defined social harm of a crime is, you simply look at the definition of the crime in the statute. You look at the words in that statute that express the external acts that we don't want to have happen, and that is the social harm of that particular crime. For example, take burglary. The definition of burglary is breaking and entering of the dwelling house of another at night with the intent to commit a felony. So, the social harm of burglary, the external part of the crime, would be, from that definition, the breaking and entering of the dwelling house of another at night. That's what we don't want to have happen. The social harm of murder is the death of a human being by another human being. The social harm of rape at common law is sexual intercourse by a male with a female, not his wife, without her consent, and so on. That's what we mean by social harm. It's the gist of the crime. And when that social harm occurs as the result of the defendant's conduct, that is, conduct that includes a voluntary act, or if the social harm occurs as a result of some omission where there was a duty to act, then we say that the actus reus of the crime has been proven. Put simply, voluntary act or omission plus social harm, as defined in the statute, equals actus reus. Voluntary act or omission plus social harm, as defined in the statute, equals actus reus of that crime. Now, before we move to the next element of the crime, I would like to take a few moments to focus on the actus reus of the crime in terms of how you would discuss these elements on an exam. Let's assume a very simple set of facts. Alice shoots and kills Bob with her gun, so she's charged with his murder. Okay, how are we going to talk about the actus reus of this crime on an exam? Well, first, I would suggest that you briefly look and see if Alice's conduct included a voluntary act. Now, since the answer will be yes in almost every case you deal with, you should usually be able to discuss the voluntary act requirement very briefly on the exam, just enough to show your professor that you remember the concept. You would note the requirement of a voluntary act. You would define the term voluntary act. Remember, a willed muscular contraction. And then point to the facts in the case that suggest the defendant, Alice, performed a voluntary act. Here it was simple. She pulled the trigger of the gun. In the vast majority of cases, the voluntary act requirement will be a no-brainer, just like this. But you will get a few extra points for that no-brainer by pointing out the voluntary act requirement, defining the legal term, and by pointing to the pulling of the trigger as the voluntary act. Now, if Alice killed Bob because she was sleepwalking, well, then that pulling of the trigger wouldn't be a voluntary act. It would be an involuntary act, in which case Alice wouldn't be held responsible. But in the ordinary case, you should be able to show the voluntary act very simply. Now, there may be a few cases in which the prosecutor charges Alice or some other defendant for something that she didn't do rather than for what she did do, in which case, of course, you'd have to talk about the omission issue. Maybe Alice failed to act when her husband was choking on a piece of meat. So what do you do here? Well, first you mention the general rule that there's no criminal responsibility, generally, for a failure to act. Then you would look at the facts and see if they support a claim that one of the exceptions to the general rule applies. Here, there's a special status relationship, wife to husband. If so, then maybe our defendant can be held responsible for the omission, assuming, again, that all of the other elements of the crime are proven. All right. After you've solved the voluntary act or omission question, you turn to the social harm of the crime in question, which again really means that you're looking at the physical external elements of the crime found right there in the definition of the offense. And you would discuss each of these elements, one after the other, pointing to the facts in the case that support the claim that this element was or was not proven. For example, in our murder example, murder involving the killing of a human being by another human being. If the facts show that Alice did in fact shoot the gun that killed Bob, you can show that there was a killing of a human being, Bob, by another human being, Alice. Bingo! Social harm of murder is proved. Now suppose you have a different crime, say larceny. Larceny, as we will see later, is defined as the taking and carrying away of the personal property of another, which occurs with a particular mens rea that we'll discuss later. But for now, since we're talking about the actus reus of the crime, your job, if the crime was larceny, would be to determine whether the defendant took and carried away personal property belonging to another. And if the taking and carrying away of that personal property of another included a voluntary act, well, again, you have proven the actus reus of this crime. So again, the first thing to look at in any criminal case is whether the defendant committed the actus reus or external part of the crime. This in turn requires proof that the defendant's conduct included a voluntary act or rarely an omission. And second, that that conduct or omission resulted in the social harm set out in the definition of the crime.